Hi, everyone. I'm J.Bambauer. I'm playing the host for this particular installment of the Journal of Free Speech Law public panel series. This is, I think, the fourth public panel or conversation we've run with authors who have now published with the Journal of Free Speech Law. I'm joined by my two fellow executive editors, Ash and Eugene. And Eugene is here also in the role of author because we're going to be discussing Eugene's paper with A.Candeub on Section 230. A.Candeub also has a separate essay on Section 230, interpreting Section 230. And then Kyle Langvardt is joining us to talk about his essay on whether the principles of the First Amendment can scale up to the size of the speech that we see today on the internet. So I suggest that we start, first of all, by anyone who has their mug handy, reminding everyone that we're promoting here partly the work of the Journal of Free Speech Law. But next order of business is let's have each of the authors describe for just 5 to 7 minutes what their paper is about for those in the audience who haven't had a chance to read or digest fully the papers. I'm going to have Adam go first, and then Eugene will present Eugene and Adam's paper. I'll take a minute after that presentation when we have both of the Section 230 papers in case Ash, Kyle, or I have any clarifying questions since the two papers are so closely related. And then Kyle can discuss his essay, and I hope after that we will be able to link all of these works and figure out what on earth should be done, if anything, with moderating content on social media and the internet. Okay, so Adam, are you ready to take it away?
Yes, I am. Just give me 1 second.
For the audience,
good.
I asked Adam like 3 minutes ago to make a slide to help the conversation move faster, so he's diligently creating one slide. So thank you.
Let's see. And it is not the most beautiful. I'm afraid. Did this share?
Yeah, that works. Okay. We can see it's not in presenter view, but you know.
I'll put that in presenter view.
Okay.
And I didn't. My spacing is not ideal. I apologize for that. I'll put it in presenter view. Hopefully, it will make it up for my bad PowerPoint aesthetics. So, Section 230 is, of course, the most important statute for liability on the internet. It's been called, I think somewhat hyperbolically, as the statute that has allowed the internet to occur or to, central to its development. And I would say in response that I think it has pushed the internet to develop in a certain way. Namely, it's been very protective rather, towards social media. And it has really allowed the internet to give voice to types of discussions that we normally would have kept between ourselves. And, is that a good thing or a bad thing? I will leave it to the policy people to think more deeply about it. But the point of the article is that courts have taken this provision, which is already very protective of internet platforms, and really made it even more so in a way that ignores and forgets not only the text, but also the context of communications law going back centuries, into which Section 230 is a part of. Section 230 was passed as part of the Communications Decency Act, which was in turn codified and passed as part of the Telecommunications Act of 1996, which in turn was codified into the Communications Act of 1934. So I think what's often forgotten is that we're looking at a telecommunications statute. And there's a lot of history that goes along with interpreting that, which I think courts have forgotten. So here we are. It's a somewhat unattractive version of Section 230C. And this is, for those people who follow the area, famous, if that's the word for it, provision. And so the article starts by looking at C1. And C1, despite a lot of what's said in the press, which and popular accounting, which tends to concentrate on C2, it is C1 that courts have mostly used. C1 has provided most of the protection for the platforms in the district and circuit courts, and it has been read extremely broadly. So let's take a look at it. It says, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Now, I'm sure everyone's mind already glazed over, the 7 words into that. It's rather dense. But just, going through it, it says no provider or user of an interactive computer service. That's a defined term in the statute. And that pretty much means, at least for purposes of this discussion, an internet platform. That's Google, YouTube, Twitter. So what it says is Google, YouTube, or Twitter, or for that matter, your own website or a website for your local restaurant. So keep that in mind as well. So the statute says YouTube, Twitter, or small website shall be treated as a publisher or speaker. Now, of course, those are terms of art, and that refer to primarily defamation law, but also things like threat and other things. And it means someone who, well, publishes or speaks something, some content, of any information, so any publisher or speaker of any information provided by another information content provider. Now, information content provider is a defined term, and of course means anyone who provides any content on the internet. So what this means is that Google, YouTube, or your local website shall not be treated as the publisher or speaker of any information provided by any other user of the internet. So that means that if YouTube, you say something defamatory on YouTube or post something defamatory on YouTube or on Facebook, Facebook is not liable. And the article takes aim at the rather expansive understanding that the courts have used. And generally, it seems to me that this provision, which is very much like the common carrier and other conduit immunities, is really focused on liabilities that of third parties. It involves legal liability that results from the content of third-party posts. And what we've seen, and largely I think it really is an example of just a very sloppy misquotation, is that test has shifted to whether or not the platform is exercising its so-called editorial functions. And it's a language from an influential case, Zoram. What the courts have said is like, well, whenever the platform itself exercises editorial functions, then it has immunity. So that's a slight shift. That means if the platform itself decides to censor you, if it decides to get rid of all women or all Jews from its platform, that's a function of its editorial function, or it's exercising its editorial function. And many courts have said, oh, the platform's immune from discrimination laws. If the platform says, oh, we accept comments from all people and we would never censor your speech, and makes that an express promise, the court would say, well, censoring and editing, that's an editorial function. So under C1, the platform is protected. And one of the points of the article is like, this is a bizarre extension of an already very generous provision, because it essentially says the platform as editor is immune. And that's not the point of C1. The point of C1 is that, just like the telephone company, just like telegraph companies, you're not liable for the content of third parties' posts. Your own editorial decisions, your decisions to kick people off the web or to make promises and not follow them about the content, that's not protected by C1. And unfortunately, a lot of courts, including some circuit courts, have gone off in the wrong way. Now, fortunately, I think Justice Thomas's concurrence in Malwarebytes, a very interesting statement by the Texas Supreme Court, as well as several dissents in some high-profile cases in the courts of appeals, have been moving the other way and have been recognizing that, really this immunity has to be cabined in. That's really the first part of the paper, is that courts have gone astray. They've taken a generous provision and blown it up to essentially a get out of jail free for the platforms, and it just doesn't make sense because they're immune from consumer fraud laws, anti-discrimination laws, contract laws, because they argue that these are all statements that we're making about the services we provide, namely our platforms, and these are editorial judgments. So the second part is, well, okay, if that's what C1 is, C2 was intended to further Congress's goals, which was it tended to further Congress's goals, which was to essentially empower platforms to get rid of pornography. And we're going to talk about this more with Eugene, but the point is that the immunity in Section 230 for content decisions is not found in C1, but in C2, and that we argue that the scope of these decisions is quite small. That the immunity for editorial functions and the exercise of editorial functions is really just for this list found in C2, which is obscene, lewd, lascivious, filthy, excessively violent, or harassing, or otherwise objectionable. These are all terms that were common in communications law and refer to areas that have been regulated and have been regulated with the approval of courts. So if you read the statute this way, the last part of the article looks to whether or not it's unconstitutional, whether or not it would be violate the First Amendment if we had a statute that essentially granted the platform's immunity for third-party content, but had this very somewhat narrow, or I wouldn't call it narrow, focused liability protection for types of speech that typically had been regulated on other media like broadcast and cable. And I'm very appreciative for the insight and help of Professor Volokh, because I've never really done First Amendment law like this before. I don't do this sort of pure analysis, but the results I think are somewhat tentative from the article. I think it is clearly a content-based statute. I think the bigger question is it a viewpoint-based statute? And to me, the biggest problem is excessively violent. I think that the prohibition, and I think I'm running out of time, so I'll quickly wrap up. The prohibition on constitutionally protected speech, which is excessively violent speech. Supreme Court has ruled that, at least in the context of video games, this is protected. And that a statute that singles out that type of protected speech could raise constitutional issues, although I'm not sure if it does. And I think that there are remedies available other than striking down the whole statute. So is that okay, Jane?
Yeah, that's great. Yeah, so then I think Eugene will sort of pick up there. That the idea at the very end, I just want to make clear, is that if there is some independent route for liability based on discrimination or the purging of content, that's where this interpretation of C2 is particularly important. Okay, so that takes us to the next essay, Eugene and Adam's paper together. Eugene?
Thanks. Very much my pleasure to be involved in this and to talk to all you folks about this. I'm going to be presenting about 230C2, which is based on an article that Adam and I wrote together. It was Adam who brought me around to this idea when I was holding the opposite view. So I very much appreciate his guidance on this. So let's look at 230C2. Section 230C2 provides that no provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or objectionable, whether or not such material is constitutionally protected. There's actually been comparatively little litigation about 230C2 compared to 230C1, and there's a reason for that. 230C2 is a defense that online entities, whether it's big ones like Facebook and YouTube and Google and such, or I'm going to use YouTube as a separate entity, even though it's owned by Google, but just to signal that particular function, or could be my blog with respect to its comments. We could raise that as a defense if we're sued, but first somebody's got to have something to sue over. They can't sue us for First Amendment violation because we're private entities. They can't sue us for wrongful political discrimination, generally speaking, because there are no laws banning, generally speaking, wrongful political discrimination. But let's assume that there was such a law. And in fact, there are in some jurisdictions. There are laws that ban public accommodation discrimination based on political views. Seattle is an example of one such jurisdiction. California might be another. Imagine that a state rules, and I don't know of any state so far that have, as to those kinds of public accommodations laws, they have ruled so with regard to disability accommodations laws. Imagine a state rules that YouTube or Facebook are places of public accommodation, and that the state or local public accommodation ban, public accommodation discrimination ban applies. At that point, the platform might well find it very important to raise a 230C2 defense, saying, we deleted this material because we find it objectionable. And the question is, can they do that? So there are two possible approaches. One approach is to say, right here it says, or otherwise objectionable. And otherwise objectionable is a very broad category, right? So if somebody says, I find this objectionable because I believe it spreads misinformation, or I find it objectionable because I believe that it conveys evil political views, it's supposedly racist or supposedly blasphemous or supposedly anti-transgender, so I find it objectionable. And it's perfectly plausible just on first read to say, well, that's a form of objectionable. It's a good faith belief that it's objectionable. Good faith usually means honest statement. Honestly, the platform finds it objectionable. So that's one possible approach. The other possible approach invokes a legal principle, which is called eius dem generis, which means roughly, as I understand it, of the same kind. And here's a classic quote from the Supreme Court on the subject, where general words follow specific words in a statutory enumeration. The general words are construed to embody only objects similar in nature to those objects enumerated by the preceding specific words. So one example, and I'm making this up, there are lots of examples from statutes, but just to make it easy, imagine that there was a law that regulated cars, SUVs, pickups, trucks, motorcycles, or other modes of transportation. And the question is, would an airplane be covered? Well, it is a mode of transportation, but it doesn't seem to be like all the others, which seem to be land conveyances. Likewise with a boat. You might say a boat might not be covered under the principle of eius dem generis because all the other things seem to talk about land transportation. And then you might look at other contextual cues to try to figure it out. But the point is when it says or other modes of transportation, it shouldn't be read on its own. Is this a mode of transportation? It should be read in light of what comes before. So returning to this, what we might say is otherwise objectionable must be objectionable in the way like what all the other things, like how all the other things are objectionable. Now, of course, you might say, but what way is that? And maybe if we can't find a common bond, that would suggest that, that we can't find anything similar in nature. There's no shared nature. So as a result, the only common bond is they're objectionable. And it does look like the first four items are all about sex. Then excessive violence is about something else. And then harassing is about something completely different. So what Adam and I point out is that those terms do have something in common. And one of those things is that every one of those terms, except possibly the excessively adverb, but that too fits in as well, every one of those terms appears in other provisions of the very same act that was a sub-act of the Communications Act in which this was enacted, the so-called Communications Decency Act. So let's look at the title. Title 5, Obscenity and Violence. Subtitle A deals with obscene and harassing use of telecommunication facilities. Obscene or harassing communications, which covers obscene, lewd, lascivious, and filthy speech. Of course, all the italicized items are the ones that are seen in 230C2. Obscene programming. And then subtitle B is all about violence. Section 551 is parental choice, mostly focused on violent and sexually themed programming. And Section 551 actually specifically orders the FCC to prescribe procedures for rating sexual, violent, or other indecent material, but specifically treats completely different regulation based on political or religious content and says, no, we don't authorize any rating schemes for political or religious content. So, and if you want to talk about excessively violent, that actually appears not exactly in this statute, but in other previous telecommunication statutes. So what we think is going on here, what we think is the sound way of applying the justem generis principle here, is that those terms, these terms right here, these terms right here are all terms that basically refer to material that had historically been viewed, both in the past and in that very statute, viewed by Congress as specially regulable in telecommunications. Sexually themed material in one way, violent material in another, harassing in another, but all of that was that. And Congress specifically said that political and religious content, again, later in that CDA, unlike sexually themed and violent content, is not something that is within the scope of such regulation. So if we're right, then what that means is, first, a plaintiff must still show some law that restricts a platform from taking down material, and there aren't a lot of such laws. Maybe there are no such laws. Maybe there shouldn't be such laws. Maybe platforms should have the flexibility to take down whatever they want. But if the plaintiff does into such a law, either an existing public accommodation law, some other existing law, or perhaps a newly enacted law, then in that case, the platform is entitled to trump that law with its federal immunity if it's trying to regulate material based on the traditional categories of material that had been regulated in telecommunications. Sexually themed material, violent material, harassing material, or other such material that had been traditionally regulated in telecommunications. Threatening material might be an example. But if it says what's objectionable to us is its political content or its religious content, that is something that 230C2 properly read just doesn't cover. With that, I close.
So how does, if that's the proper reading of C2, wouldn't Reno versus ACLU's holding suggest that at least that part of Section 230C2 is unconstitutional anyways by promoting the private censorship of certain legal speech, but not others?
That's a great question. It's an important question. I think the answer is no. So let's just step back a bit. Reno v. ACLU says the government may not impose content-based restrictions on internet speech, just like it can't generally impose content-based restrictions on other speech, with some exceptions, such as for defamation and true threats and such. What Reno doesn't tell us is, what about governmental speech protections? What if the government protects speech from private restrictions and does so in a viewpoint neutral way, but a content-based way, in a subject matter-based way? Is that unconstitutional as well? And the answer is the Supreme Court has not squarely dealt with this issue. But let me just offer a couple of analogies. In Massachusetts, there is a legal rule that the Massachusetts High Court developed, which says that private shopping centers, like throughout almost all the rest of the country, they don't have to allow speakers to come on the premises, that the state free speech clause doesn't mandate this access. But the state initiative and referendum provisions and signature gathering provisions more generally do mandate access for signature gathering related to elections. So that is a viewpoint neutral but content-based protection for speech against private retaliation. So you might say that's unconstitutional. Either you have to allow everybody on premises to speak about anything, or you have to leave it entirely to the private entity's discretion. Maybe it's possible, but I'm inclined to say that it's probably allowed, permissible for Massachusetts to do this. Let me give you one other example, and then I'll close my answer. Many states protect private employers from retaliation by their private employees, from firing for political activity by their employers. Some of those are very broad protections for a wide range of ideological speech. Some of them are narrow protections for only campaign-related speech. About half the states have this in one form or another. So you might say that's unconstitutionally content-based because it only protects political activity and might not protect in some states, again, might not protect non-campaign related activity, or might not protect, even in states that define political activity broadly, like California does, it only applies to things that are loosely political and ideological, might not apply to, I don't know, talk about sports or something like that. I'm inclined to say, and again, there's no case law on this, but I'm inclined to say that states are allowed to provide this kind of content-based but viewpoint-neutral protection against private retaliation, and that those statutes are indeed constitutional and couldn't be struck down on the grounds that, well, you have to protect either all speech against private employer retaliation or no speech. But maybe we're wrong on this.
Yeah, Gene, I'm a little bit confused because it seems to me that 230C2 does something very different. It's not protecting speech. It's stripping speech of protection by authorizing private retaliation, right?
So what 230C2, as we understand it, means is that that state laws could protect speech against private retaliation, but not speech that is filthy, violent, or harassing.
Right.
So it sets up a scheme where there could be these kinds of content-based rules. What it doesn't do is it doesn't restrict the speech. It simply says if private entities can want to restrict the speech, they can if it falls within this category. But if it doesn't fall within this category, then it's up to state law.
So let me actually then one follow-up question. We should turn to Kyle. But so one of the biggest problems is libel, right? Someone posts something on a platform that libels another private individual. Because of Oakmont, there was a risk that the platform would be held liable for that libel. Right. C1, so that's difficult. C1 says you can't do that. Right. What you're telling me is C2 does not authorize the platform to pull the false statements down because falsehood, disinformation does not seem to be included. So the platform, if it takes down the false statement about another individual, risks a lawsuit, right?
So here's why it's important, I think, to recognize that C2 just provides immunity from liability. There's got to be an underlying ground of liability.
How about breach of contract?
Well, if the platform does say to me, we promise, absolutely promise, we're not going to take down your material unless it's obscene, lewd, lascivious, filthy, violent, or harassing. And then I post something, they say, we're taking it down because it's libelous. Well, then they have indeed breached the contract, and I don't see
but let me give you a
why
simple
230C2 should protect them.
The terms of service say we're going to pull down libelous things. I post something that someone else says is libelous. Platform pulls it down, I sue them and say, actually, this was libel.
What are you suing them for?
Breach of contract.
There's no state law that bans platforms from taking down libelous material. If the state wants to enact such a law by saying essentially we don't want platforms to be in a position of being judges of libel, or it says we want platforms to be common carriers without making those kinds of decisions, then in that case 230C2 would indeed preempt that. I just don't know of any states that have passed such a law.
Well, I think that Texas and Florida have come pretty close.
Well, so let me give you an analogy. So phone companies are indeed common carriers under state law. And I believe they don't have the discretion, at least the one case that I've seen that deals with that, they don't have the discretion to say, we think your outgoing voicemail is libelous, so we're going to cancel your line, or at least pull down the voicemail. They just don't have the discretion. Nothing in the First Amendment says they have to have that discretion. So to the extent that a state does say you're going to be common carriers and you're not allowed to take down material on the grounds that it's libelous, then in that case, 230C2 does not provide the platform that kind of immunity. And
right. And so, and that might raise other First Amendment questions related to that underlying state cause of action. But I'm still confused about how, let's say that a state does that, is maximally protective. That plus, and so basically requires more or less common carriage except for unprotected or illegal content. It would seem to me, though, that if you combine that state protection with Section 230C2, you would wind up in sort of like a TAM situation where there's a benefit to be, there's a benefit.
I agree.
Okay, you do agree with that.
So you do have a situation where the government is providing a certain kind of benefit in the form of protection for private entities.
Right.
And the flip side is also protection for platforms against a certain kind of liability. So Metallo v. Tam and Iancu v. Brunetti, those remember are the trademark viewpoint discrimination cases, said the government cannot offer these benefits in a viewpoint discriminatory way. So in Tam, the government was denying it to speech that it perceived as racist. In Iancu v. Brunetti, to speech that was seen as immoral or scandalous.
Okay, and you're saying that these are content-based categories, not viewpoint.
Court deliberately reserved that question, Metallo v. Tam, and I'm inclined to say that there's a good reason for the reservation.
Oh, I completely disagree with you, Eugene. I think Metallo v. Tam explicitly says that discriminating against racist speech is a viewpoint discrimination. I think all eight justices agree on that.
No, I agree.
Yeah, he says that too.
But discriminating against libelous speech or discriminating against political speech or in favor of political speech or whatever else, that would be a content discrimination. I totally agree that if the government were to say you can take things down if they are racist or unpatriotic or anti-war or advocate for self-harm, but not in other situations, that would be an example of a viewpoint-based protection for private speech, unconstitutional.
But so something like harassing and the other categories that the CDA was sort of generally trying to protect, you think that those are safely categorized?
Well, harassing means different things in different contexts. But in the telecommunications context, there's nothing to do with what people sometimes label harassment as hostile environment harassment.
Right. It's
racist or sexist or anti-religious.
It's directed.
Right.
Harassing is like a harassing phone call. Harassing phone call laws don't single out particular viewpoints. They sometimes single out particular content, which is to say that calling someone in order to abuse them with vulgarities, for example, might be punishable. And sometimes there also are just focused on content neutral things like are you sending repeated messages maybe after you've been told not to.
I actually had one more question on this, and I think this kind of follows up on a question that Ash was asking. So Eugene, you gave a couple of examples of these state laws here. So mandatory access for signature gathering, protections for campaign activity. And so these are examples where you have a special content-based category that's singled out for some additional immunities.
Right.
But it seems to me like what C2 does is it singles out a similar kind of narrow content-based category and moves it into like this kill zone, as opposed to taking the narrow category and applying an immunity to it. Now, I'm not sure how big a difference that makes, but if it does make a difference, it seems to me like this feels a bit more like the Denver area educational telecommunications consortium case, which I think Adam talked about a little bit. But it seems to me like that's really the precedent that's the most on point here. I wondered why you didn't discuss that one a little more.
I didn't because I was told I had 5 to 7 minutes, which I think I ran over. So Denver area is quite complicated and it, for example, it upholds certain kinds of content-based, viewpoint neutral sort of authorizations of restriction, and then strikes down certain other ones. And it's also a very badly splintered decision. But I think, as a general matter, the core of what I think was going on, well, to be sure, it's only 2 justices' opinion, but I think the best explanation is that the court was, as to certain things, treating certain online material as certain kinds of cable material as a kind of public forum. That it sort of said, you know, you've set up these kinds of traditionally publicly accessible, kind of by law, publicly accessible channels, and now you're sort of stripping away that protection. Here, I think it's different because here they were never by law publicly accessible to everybody. They were just private. So I think that this is probably likely to be constitutional, again, because it's just one example of where, when the government wants to provide protection beyond what the First Amendment requires, it's generally speaking free to do that in a content-based way. I'll give you one other example. My understanding, and Adam may be able to fill me in more on this, my understanding is there were some state common carriage laws that were interpreted as basically not requiring phone companies to host dial-up. They had the constitutional right to do so, see Sable Communications v. FCC, but some of them said we don't want to do it. And they didn't reach the US Supreme Court, but I think lower courts upheld that. Lower courts said, yes, indeed, they are free to impose that kind of limitation. On the other hand, if the common carrier said, well, you can't host, or excuse me, you have the right to refuse to host racist material or anti-government or anti-war material, but nothing else, that would be impermissibly viewpoint-based. That's my sense of that.
Okay, Kyle, want to tell us about why the First Amendment doesn't scale?
So, so here's kind of my big picture on this. So we've got this classic problem where a speaker wants to use a channel or a platform or some kind of speech facility to speak. And then the operator of that facility denies the speaker access. So it's this classic problem. Today we talk about it in the context of Facebook. At one point we would have talked about it in the context of newspapers. And let's just stipulate that at least some of the time, the speaker is going to have good reason to be upset that they were denied access. So how do you deal with this kind of problem just generally at law? Well, I guess I would identify 2 strands to our approach. So the first one is that we have an approach that handles these controversies through a private ordering model. So the owner of the speech facility and the speaker bargain, at least in theory, for access, and that's how it's resolved. And then the second strand is that the courts play this role of protecting the private ordering model from public interference. And there are a couple of instruments that they use for that. So the first one is the First Amendment, and specifically the First Amendment's concept of editorial privileges. So the operator of this facility, at least in many circumstances, is going to be treated as an editor, and any attempt to interfere with that editorial prerogative is going to be subject to strict scrutiny. Then, of course, in the online context, we have Section 230, which goes even further and actually preempts attempts by state law to interfere even in ways that the First Amendment might otherwise allow. So my thesis here is that once you have giant private platforms like Facebook or maybe YouTube, essentially structuring the public sphere, the scale of that editorial operation undermines both aspects of our traditional approach to the problem. in the first place, I would say that the real selling points for private ordering largely evaporate. And second, I would say that courts, at least at this point, have lost the institutional capacity to protect free speech values in this environment. And courts just aren't equipped to handle with such a large volume of cases as Facebook looks at and so on. So in a little more detail here on the first point, with respect to the editorial principle and its value, I would say that there are a couple of ways to approach editorial privileges. One would be to say that the editor has a kind of intrinsic right as something like a speaker, and that right deserves to be protected in its own merits. But second, I would say that the editorial concept protects some instrumental values. So if newspapers have the right to control what kind of third-party content they're going to print, well, that advances an interest in expressive pluralism and ideological diversity, prevents a consolidation of regulatory power in the state. You know, if the state were to try to manage those decisions. You could even imagine certain theses that said the need for media institutions to bargain with readers and with content producers, maybe even promotes professionalism and journalistic integrity. I would say that once you have an institution as large as Facebook claiming editorial privileges, it no longer advances these instrumental values very meaningfully. If Facebook stands in as a kind of regulator of the speech of 2 billion users, well, that's a consolidation of regulatory power right there, one that's similar to state power in some ways. I would say that once you have a single editor laying down the law for all of those speakers, it's hard to square that with an interest in pluralism. If anything, you would expect it to have kind of a flattening effect. And as far as Mark Zuckerberg's kind of intrinsic moral interests in being an editor, well, I'd be willing to grant those, but just as a practical matter, I think those are overbalanced many times over by the interests of the users. And so I would say that even if, formally speaking, we can say that Facebook edits content when it regulates it, it starts to look like we've lost the plot, like we're looking into the wrong questions. Now, I mean, maybe we could acknowledge that Facebook is an editor and still provides some rights of access, but I suspect that at least the First Amendment doctrine as it stands today wouldn't allow that. There's this famous quote from Buckley versus Vallejo that the concept that government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment. And I think, you know, if we're providing rights of access to people whom Facebook would otherwise silence, well, that sounds like exactly the kind of leveling approach that the court has condemned in other contexts. And to make matters worse, I think Facebook looks even more like an editor the more it throws its weight around and discriminates on the basis of viewpoint and so on. So I think that if we are going to have rights of access, you would need to see two broad changes in our approach to First Amendment law. One would be we'd have to weaken editorial rights somewhat, maybe not go so quickly to strict scrutiny. Maybe we'd have more of a proportionality-based model, or maybe we might even look at content moderation as just pure conduct for some reason. And I think you would also have to see a version of First Amendment law that is more hospitable to a pro-regulatory approach in which we're trying to advance the rights of speakers and not just withdraw the government from regulating speech. Now, I think an even more profound problem that the scale of large online platforms presents to our traditional approach to the First Amendment is that it just produces a fire hose of adjudication that courts cannot realistically manage. So just for some perspective, at Facebook, just the human content moderators, I'm not counting the AI content moderators, the human content moderators decide something like 12 to 20 million cases every day. And you know, the largest adjudicator in the federal government is the Social Security Agency, or Social Security Administration, they handle maybe 700,000 cases a year. So this is just an enormous volume that courts and even non-Article 3 adjudicators have never faced before. A lot of these cases are going to involve a lot of substantive complexity that the First Amendment doesn't really answer especially well. For example, is Brandenburg versus Ohio's approach to incitement a workable one in the context of Facebook, where there's a closer link between speech and harm from a causal perspective? There are all kinds of new questions that would need to be answered. And even once those questions are answered, courts are going to have to provide, courts are going to have to face a problem that in other contexts has been called quality assurance. So at Facebook, Mark Zuckerberg has said that the company probably makes the wrong call in more than 1 out of every 10 cases. And inevitably, there's always going to be some kind of a substantial error rate. I think that once the law begins to regulate these content moderation decisions and try to provide meaningful speech rights, it's going to have to begin confronting this problem of the error rate and coming up with solutions for that, or thinking about what kind of error rate is tolerable and so on. And so overall, I think that even if the First Amendment can be modified to allow for some kind of congressionally implemented access rights, the courts are going to have to rely on a really thick layer of agency support, which is just a kind of institution that we don't have a lot of experience with in the First Amendment context.
Great. So I guess I'm curious, if Kyle's paper interacts with Eugene's and Adam's in the sense that even if we put aside, if we modified First Amendment, sort of theory and doctrine in order to enable some kind of general access right, right to access Facebook, what that actually means in terms of the level of government, government activity that's going to be required in order to facilitate that right, is going to be really significant. So I'm curious what Adam and Eugene think. I guess this gets to the sort of practical question of, like, if we switch to not complete common carriage, not a complete free-for-all, but something that allows some content, maybe users too, but certainly some content to be purged and others not, others protected. Who decides that? And are you ready for a new federal agency that does this sort of work?
I wanted to add that I completely agree with that. My question was going to be the same. It seems to me that, let's admit, I agree with you, Kyle, that there is an editorial right, but it's instrumental. It's rooted in the press clause. Mark Zuckerberg has no conscience rights. I don't think he does. Do the three of you really believe that government regulation, even of large entities, is superior to private ordering? Because that's the question, right?
Well, go ahead.
I'm sorry.
Ahead, please.
Well, so I think the answer is usually not. And it may very well be that here it's not either. I'm not sure. We do have a view that certain kinds of government regulation are superior to private order. That's why, for example, phone companies can't cancel the lines of the KKK or of Antifa, right? Maybe they shouldn't. Maybe they should be free to do that. Maybe that's a legacy of the time when phone companies were state-ordered monopolies. Maybe now that there's competition among phone companies, let Antifa find its own carrier that's willing to support them, let's say, maybe. But I do think we take the view that in certain areas, certain kinds of infrastructure are so important that we shouldn't leave them to private decision. Likewise, with regards to employees and political activity, not a uniform view by any means, but many states, including my own California, take the view that private ordering is not enough to protect private employees' political activity rights, and that they should be able to sue an employer if the employer fires them for political activity. Although, of course, it's always hard to figure that out because the employer will often say, "Well, no, we fired them for something else," and this is just their way of trying to cash in on the firing. On the other hand, lots of states actually do take the view that it should be left to the market. And if some company decides it only wants to hire Republicans or Democrats, or doesn't want to hire people it perceives as racist or communist or whatever else, well, then, fortunately, there are other employers, generally speaking, you can go to. These are great questions. I don't know the answer to them, but I do think we need to talk about them through this kind of policy analysis rather than just assume, and I don't think we should assume, that they do have categorical First Amendment rights to exclude, just as universities don't have categorical First Amendment rights to exclude recruiters, just as shopping centers don't have the categorical rights to exclude leafletters.
Yeah, and I would add too, and it goes back to the court's interpretation of C1, is that, we're not excluding private ordering. The platforms can say, we will not carry hate speech. We will not carry speech that, we deem objectionable to transsexuals. But the problem has been that C1 has been interpreted so broadly that there can't be private ordering because the terms of service have been read non-justiciable under Section 230 immunity, so that people in fact can't contract in a fair way for those issues. So yeah, I mean, if you want private order, we have a place for private ordering, but we have to have private ordering there. And right now we have sort of government protection.
But let me actually restate my question then, because you two know much more about 230 than I do. I'm sort of thinking, so hate speech. So you're saying absolutely private ordering permits carriers to ban hate speech. But in fact, Texas and Florida have just said you can't do that because they've required viewpoint neutral content moderation, and a ban on hate speech is viewpoint based, see Mattel v. Tam. Mm-hmm. So my question for you is, do you think what Florida and Texas have done is superior to letting these platforms make their own rules?
I'm not sure it's superior. It may not be superior. And also, I think the way they did it is, at least I've looked closely, the Florida one is unconstitutional just for a particular mechanism. But my view is that this question, whether it's in the employment context or the platform context, of to what extent do you want to protect public debate from private institutions that suppress this? Don't just sort of speak up on their own and buy their own ads. I'm with the majority on Citizens United as to that, but actually suppress speech on their property, but tremendously important property, or suppress speech by their employees, only through threat of removing their paychecks, but that's tremendously important threat. How we should deal with that, I think it's an interesting and difficult question. I would like to see some states experiment with it. In a few and experiment with it with properly crafted laws, and then we may learn. We may say, oh my God, the cure is so much worse than the disease. Perfectly possible. But I do think there is room for experimentation under the First Amendment here, just as there has been with regard to lots of other platforms, again, whether university or cable system or the shopping mall or UPS and FedEx, which are treated as common carriers, or as to phone companies. There's been room for that kind of experimentation, and query what the right lesson to learn from those experiments is.
So I want to go back to I'm sorry, go ahead, Kyle.
Oh, I was just going to say, I think one concern that I have, and I hope this isn't the case, is that there's no way to resolve the public ordering versus private ordering question a priori, and that it all just comes down to who's in charge. Do we trust management at the dominant platform more, or do we trust the public regime more? Now, I'm not sure that that's the case, but I fear that the distinction between public entities and private entities as managers or regulators or governors of speech are becoming increasingly thin.
Right, because
in
this
depth.
gets to the market because it's not a thick enough competitive market.
Mhm.
Well, so that's what I wanted to press on, because I hear two different theories of what's wrong with the market. And I would love to hear Adam and Kyle respond to each of them. So Adam's suggesting that actually it's not a market because even if a company promises, for example, to conduct its content moderation in neutral ways, it can get out from under that contractual promise anyway, thanks to the generous interpretation of Section 230. And I guess I wonder, if descriptively, is that right? There are cases like Barnes versus Yahoo where certain contracts are enforced. And then even if generally speaking, Adam is correct, well, maybe that's a narrower, easier problem to solve than some of the other. So that's the question for Adam. But then for Kyle, I guess I'm wondering, I still take the view, and I think Ash and I are on the same page with this, that actually Facebook, while it's dominant, it's still in a somewhat defensive position. And actually, the more it edits in the US, kind of proves it. Like the rest of the world, the rest of the world, it doesn't make as much money off of those users, and so it does not actually do much content moderation. Whereas in the US, it seems to be responding by doing the moderation that its median user seems to want. So I guess I'm wondering why you're so confident that this is not actually a well-functioning market.
Okay,
Well,
Yeah, sorry, I threw two questions out there. Kyle?
Sure. I mean, I guess what I would say is, even if it is a well-functioning market, I wouldn't, even on that assumption, I wouldn't say that the values the market surfaces are necessarily going to reflect the kinds of values that we would want to promote in a system of free speech. I mean, free speech has a strong kind of counter-majoritarian aspect to it. And at any rate, I wouldn't say that market choice is a perfect substitute for voting in a public process. So I guess then another point that I might raise, and maybe this is a little bit to the side, is that if the platforms are engaged in robust competition, a lot of that competition is going to be for advertisers. And as long as the competition is advertiser facing, that's going to translate into incentives to make the platform more addictive, more conducive to kind of compulsive speech, more conducive to the type of speech, therefore, that seems to call out for censorship. And so you get a platform that looks more and more and more like the type that relies on content-based takedowns as a first resort rather than a last one. So competition could, in a lot of respects, make things worse. Yeah.
Adam?
Yeah, I'm just gonna say briefly, I mean, I think competition, I think, could be very, very salubrious. So getting back to your point about Barnes, which is sort of cited more, as a matter of form than a matter of content, that case involved an oral promise, a special oral promise made to the plaintiff, and the court said, "Oh, that doesn't come under Section 230, so we'll say that's okay." But in fact, I think it's fair to say that a lot of courts go the other way. I haven't counted them, but I would, if I had to bet, I'd probably say most say that, look, promises made in the terms of service are protected by 230, and that has a very unhealthy effect on competition, because when a platform promises, "Oh, we're going to be the free speech platform now," everyone can sort of say, "Well, whatever your promises are, Section 230 will allow you to ignore them." So I think that's a very real problem in differentiation. But let's say we had our world where Section 230 did not protect terms of service, where they had to defend them in court. And I think that actually that would be a really good conversation for the courts to have, because you look at the contract and says, we do not support hate speech, and people can say, well, is this hate speech? We can understand the contours of these categories, because right now, one of the most frustrating and difficult parts is that it seems so arbitrary.
Right.
And, if we're concerned about litigation, I'm sorry, we're talking about litigating against the richest companies in the world, I'm not so sympathetic to that. And if they, they have a choice, they want to impose this regime. It's good, as Kyle points out, for their advertisers. So let them pay for it, and let them pay for the promises that they make. And I think that would be a good result.
Interesting. Okay, great. Well, we're at the end of our hour. Can't thank you enough. For those who are watching live or on YouTube, there are a few more public panels coming up. I think the next one will be December 1st, featuring Eugene as the host with Jack Balkan, Daphne Keller, and Mark Lemley. And thanks for joining us. Thanks to my panelists.